Lelchook v. Societe Generale. Counsel?
Good afternoon. May it please the court. My name is Michael Radine, speaking on behalf of plaintiffs' appellants. I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
The Second Circuit asked if, under New York law, a predecessor's jurisdictional status is inherited when the successor assumes all of the predecessor's assets and liabilities. The great weight of persuasive authority, as the Fourth Circuit put it, says it does, and it should here too. As the Second Circuit noted, jurisdictional status is clearly inherited in cases of merger, de facto merger, and mere continuations on the one hand, but not in cases of simple asset acquisitions on the other. It then posited that the scenario before us today, where the defendant acquired all the assets and liabilities of the tortfeasor, appears to fall into the, quote, cloudy middle ground between those ends of the continuum. We submit that the question, therefore, is what meaningfully distinguishes a merger, de facto merger, and mere continuation?
Well, why isn't just a form selection clause resolve all of that? I'm over here, sorry.
Oh, sorry.
Sorry, counsel.
A form selection
Right,
clause.
parties, foreign selection clauses, why not just resolve the issue that way? That would be an express statement of what the parties want to do and what they intend moving forward.
Well, of course, the plaintiffs have no control over the contract between the parties. They're
That is
essentially-
true, but this is about the intent of the party that's assuming the liabilities, right?
While that would be a clear expression, the acquisition of all the liabilities, where those liabilities include claims that are cited in New York, should also be clear enough. As courts have pointed out, corporations in
Well, would there
purchasing
be
each
a
other.
difference between existing claims and ones that don't exist yet?
No, I don't think there is. I think that both existing claims and claims that don't exist yet, in the sense that they haven't been brought yet, they have accrued, but they have not been brought yet, there wouldn't be a difference. It is certainly eminently foreseeable that those claims could be brought in New
And
York.
do you need both the acquisition of all assets and all liabilities, or just the liabilities? What's sufficient?
Well, of course, the question is under all assets and all liabilities, but
We understand, but I'm asking you, suppose it was just all liabilities.
sure. Well, the great weight, persuasive authority the Fourth Circuit referenced was referring to not only just liabilities, but just the liability in question. So here, for example, tort liabilities. But what happens when a corporation takes all assets and all liabilities is that it essentially takes all the value of the corporation that is hailable in the jurisdiction and removes it, along with the liabilities that would offset those assets. So the result is something that's eminently unfair to creditors and plaintiffs.
Well, so you could think of an insurer as somebody who has assumed liabilities under certain circumstances. So would your rule be sufficient to render foreign insurers liable here directly?
Well, if they've acquired all liabilities, then they would be liable. The question is would they then be hailed into
Yes.
the jurisdiction?
jurisdictional,
Presumably,
yes.
they have acquired those liabilities in order to defend them, as opposed to remove them from the jurisdiction. But if the question is whether
could you sue them directly here, or would you need to sue the insured party?
for that liability, well, the insured party there, of course, would, under that insurance policy, has the power to gain indemnification.
Sure.
When all the assets are taken, the
Would that
corporation.
be a fair reading of the liabilities transfer here?
Well, sorry, Your Honor.
Let me ask it a different way. LCB continued to exist, correct?
Nominally. All it does
Oh,
is defend this
well,
lawsuit.
Okay, but it received several hundred millions of dollars, right?
It received $580 million, most of which were all gone.
Well, all gone now, but as of the moment of the asset and liability agreement, right, the execution of that agreement, LCB still existed. Yes?
Nominally, yes.
Well, it had, I mean, if I have $580 million, I think of myself as having a little more than a nominal existence, at least financially.
Well, leaving aside even the significant portion that was immediately seized by the United States before it even left escrow.
Okay, seized is frozen, that's not a determination, but okay, leave that aside for a minute.
Their liabilities, $580 million is a lot to you and me.
Yeah.
But to a corporation with the liabilities, the scope of LCBs, it's a pittance.
Well, I understand that, but I'm asking a more of a theoretical question, not that has to turn on how much money was left there. I mean, if you suppose it had been $500 billion, more than enough to satisfy your judgment. My question is, could you have sued LCB here? There would still be jurisdiction over them, right?
Yes.
And if they had an insurer who was liable for that particular judgment, let's say, could you just sue that insurer here, even if it was a foreign insurer, without suing LCB?
Well, in that case, LCB, so I suppose, has all of its assets if it simply transferred its liabilities.
Yes.
And certainly under New York law, you could sue either the tortfeasor corporation or whoever's acquired its liabilities. As for the jurisdictional question, it seems that there may be less of a danger if there's been, if the assets haven't left the jurisdiction. And that's certainly the basis for other courts' holdings about de facto mergers or mere continuations, that the assets have left the jurisdiction.
Would you still have the opportunity, or the court or the parties, to do a personal jurisdiction analysis based on the business the insurer has with an entity that has New York connections? I mean, I assume in part the Chief Judge's question is that if there was no other ground for personal jurisdiction against that insurer, I think that's in part what the question was, could they, based on your argument with respect to the company, also sue the insurer under that same theory? Because if you otherwise have personal jurisdiction under some other theory that's obvious and clear, we're not going to talk about that now, can you use this theory against an insurer? Because they've insured the party.
Right. I don't know that the plaintiffs, the needs of the plaintiff are implicated where an entity has simply offloaded its liabilities but not its assets.
And
Does
why,
not seem,
why are the needs of the plaintiff the only relevant touchstone we should look at? I mean, if you look, for example, at our decision in Seminets, which I realize is a liability decision and not a
Right.
jurisdiction decision, it suggests that appreciating or accounting for the impact of a rule on businesses is something that should also be taken into account.
yes, and as the Second Circuit said, the expectations here on the corporation are having purchased liabilities that it knew what they were. It didn't have to.
So is your view, I mean, presumably, we're talking at least about, a rule that would apply to the purchase of all assets and liabilities, not specifically the parties to this case, right?
Correct.
And so if that's the case, is it your view that that expectation is different in kind and a lot more robust than if you're simply buying a product line?
Yes, yeah. The
And
product-
why is that?
Because there's not the concern with the product line rule necessarily that there's an incentive to remove assets out of the jurisdiction, perhaps to evade a litigation just like this one. The basis for our argument here is the same as the one for the underlies de facto merger, mere continuation mergers, the other scenarios in which the courts here already find that that personal jurisdiction is, that status is inherited to the buyer.
So that seems to me to be about the question of the incentives that we're setting up. But to go back, if we can, to the fairness point for a second and your exchange with the Chief Judge. So if there's $500 million in assets that LCB has, and I understand you're saying only for a short period of time, but how do the fairness concerns play out there if you have plaintiffs who presumably could file as against that $500 million?
I think that the issue is not that it left no cash behind, if you will, but that the cash is insufficient for the liabilities that they purchased. They bought a company that had $6 billion in assets and paid $580 million
But that's not going to be
for it.
true in every case, right? I mean, and that's why I said it seems to me the level of generality that we're looking at is what's the rule with respect to the purchase of all assets and liabilities, not specifically with respect to the financial circumstances that the parties here have, right?
Yes, Your Honor, but the rule is preventative, as in the rule does not, as in so many rules that seek to deter or prevent unfairness to a party or, a fraud on the court or on the party, the rule doesn't only kick in after it's shown to have been needed. The statute of frauds is true whether or not the oral the oral contract was valid or not. The idea is that the rule prevents.
You might have a rule that kicks in when it's needed, which would be something like, if you showed that the transfer was for the purpose of avoiding jurisdiction, then there's jurisdiction.
Well, I think that it certainly should be included in the rule in the sense that it would cover that situation as well, but I don't know that the intent necessarily matters.
Well, no? I mean, it seems to me that in a lot of the cases, the concern that's expressed is not allowing parties to set up corporate entities elsewhere for the purpose of avoiding jurisdiction and avoiding the liability that would be easy to satisfy if you had jurisdiction and very difficult without it. And that could be accomplished by a different sort of rule. And so when you were mentioning the difference between $580 million and $6 billion, that's what struck me, is that you're really kind of arguing for a rule like that.
Well, it seems that instead of trying to make that determination in every case, just as that we don't ask for in other situations of inherited jurisdiction, whether there's an insurance policy or indemnification that could cover plaintiffs. We simply have a rule saying we're not going to allow a buyer corporation to take the assets and liabilities out of the jurisdiction without being at least hailable here. Of course, there's no question that the buyer is liable in these scenarios. So that they already face. The only question is whether they have to defend it here or there. And the argument we're making is that in this situation, it's fair to have them defend the case here in New York where they purchase liabilities that include.
Why couldn't you have pursued the case, maybe you still are, against LCP to judgment, gotten a judgment of whatever amount, and then tried to enforce that using the assumption of liabilities provision?
You mean enforce it in Lebanon,
Yeah.
where SGBL
Yeah.
is? So I see my time's expired. Let's answer Your Honor's question. I think that it's in New York's interest to provide enforceable judgments. I think that judgment enforcement is much easier where the court has jurisdiction over the judgment debtor itself for a variety of reasons, whether it's for discovery or for seizure or for other practices that assist in that process. As this court said in Grant Howard, that the Schumacher forms of acquiring liabilities are, quote, consistent with the desire to ensure that a source remains to pay for the victim's injuries. And I think that means a source that this court has control over and can make demands of rather than sending plaintiffs out to try their luck abroad.
Chief, may I ask one last
course.
question? You say at footnote 7 of your brief that SGBL made claims in the Southern District. But you're not arguing, I take it, that they purposefully availed themselves here and therefore, satisfy 302 on their own terms. Is there a reason that you aren't making that argument, or maybe I'm missing something? How does that play into our analysis of successor jurisdiction?
We highlight that to, I'll say the reason why we don't rely on that is that's not the Second Circuit's question, is whether SGBL's own conduct
Yes.
also.
But did you litigate that in the federal court?
Was that
Rely on
raised
that in the federal court?
to the Second Circuit?
No, in the district court.
Oh, the district court, I don't believe so. We raise it simply to make the point that the jurisdiction is one that, for the same monies as in the purchase money, that the buyer will come here to take advantage of the jurisdiction to make sure it retains, but then argues that any monies it has are outside of this court's or courts of New York's jurisdiction when the plaintiffs come and seek them. Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court, my name is Brian Lesky. I represent SGBL in this matter. An out-of-state asset and liability purchaser does not inherit the jurisdictional status of its predecessor under New York law for 3 reasons. First, it is black-letter law that there must be a statutory basis for personal jurisdiction, and it must be applied to each defendant to a case. Here, CPLR 3021A authorizes jurisdiction over an out-of-state corporation based on its own conduct within the forum or that of its agent.
But does it apply to successor jurisdiction in an instance like this?
It does, Your Honor. Plaintiffs have made the argument that the long-arm statute only has to be applied to the predecessor, but there's no basis for that conclusion. Each defendant, due process has to be satisfied with regard to each defendant to a lawsuit. And if a lawsuit involved two tortfeasors where the claim was made against both of them, the court would apply the long-arm statute to both of them.
But wouldn't that make, I was going to say, wouldn't that make successor jurisdiction irrelevant, essentially? I mean, if you have to show that the party independently satisfies 302 without regard to whether the predecessor satisfies 302, then you're not really inheriting or imputing anything, are you?
Well, I think you are, and I think the way to look at it is this. The courts that have considered a successor liability theory have found that it's not the fact of liability that's important, it's the basis for successor liability. And virtually all those courts that have looked at that issue have found that where the predecessor and the successor are one and the same, meaning where a plaintiff has alleged plausible facts of alter ego, of merger, of de facto merger, of a mere...
But the question here is whether to go further.
The question...
Nobody's debating
Yeah.
what you've just described.
Yeah.
Everyone acknowledges those exceptions.
Yeah, so I don't think...
Why
there-
not go further here,
So I don't
given
think...
accepting all assets and all liabilities?
I understand. I think the analytical point here is that the entities are the same. So the contacts of the predecessor are the contacts of the successor. And you're just going ahead, actually, and applying the long-arm statute or applying a due process analysis. So that's where the successor liability comes in here.
Well, to me seems maybe a bit tautological, right? I think the question, as Judge Rivera says, is should we also do that when there is a purchase of all assets and liabilities, understanding that we, in other jurisdictions have, at least other jurisdictions have done it with respect to a merger, whether actual or de facto.
Yeah. Well, two answers to that. First, obviously, the text of the long-arm statute itself, when you apply it, makes no reference to successors and only imputes contacts, which is really what you're doing.
But the long-arm statute then wouldn't really even allow you to reach a merged entity, right?
Well, this court has not reached the issue. The Second Circuit certainly has weighed in, and again, the analysis...
Well, no, I guess what I'm saying is you seem to be saying if this had been a merger, there would be jurisdiction. Because it wasn't, there isn't.
Yeah,
So far, with me so far?
I am with you this far.
Okay. So, but I don't then understand how, under your statutory argument, a merger would fit into this if it's a New York corporation that's merged into a Delaware corporation.
So the analysis that has been adopted is that only one entity survive a merger. And both the predecessor and the successor survive in that entity. So you're back again to the analysis that those entities are one and the same. So the jurisdictional context of the predecessor are the jurisdictional context of the
So
successor.
does that require...
And that's not the case. Oh.
And that requires the predecessor no longer exists in any form.
Well, a merger is normally
Right?
not an...
But that's what I
yes,
mean.
yes, yeah.
There's
That's
now
right.
only one entity that
One
remains.
surviving entity in that situation, and it's not an all-cash transaction like an asset and liability purchase. And I think this is what the court is looking for. The difference between the scenarios of de facto merger, a corporate reorganization, a merger, and an all-cash asset and liability purchaser is threefold. First, there are two legal entities involved here.
Counsel, just, I interrupt you, but understand that. But does it matter the basis for long-arm jurisdiction that's asserted? Because and again, maybe going back to something the Chief Judge said early on, which is you bought assets and liabilities to the company, and the basis for jurisdiction here is A1, doing business, and the doing business that we found gave long-arm jurisdiction was the corresponding accounts in New York. That money was going through. So you bought assets, you bought liabilities, you bought that business, presumably you bought that asset with the goodwill that comes with it from doing business in New York. Why don't you buy this too?
Well, if we're talking, this lawsuit was not filed till well after. If a company used assets that were purchased, then there's going to be jurisdiction.
Yeah, but you bought those assets. You bought presumably the ability to do that business here, corresponding accounts, right?
And if the claim arose from those assets, this claim did not arise from the purchase of those assets. It happened 9 years later. And Greenberg is a very good example of that, where a New York company, where the owners of the company dissolved the company and took it to Canada. And this court looked at it, and it didn't find that it was a successorship and that therefore there was jurisdiction. It found that it was that the Canadian company, the reincarnated version, was doing business. And it hinged its analysis on the long-arm statute. It just didn't simply jump ahead and say, successor, predecessor, there's going to be jurisdiction. But the two other reasons why an asset and liability purchaser is different is that two companies survive the transaction and go ahead and do their own thing. And the third thing, which is probably most important, and that's clear on the record here, is that there's no continuity of ownership of the predecessor in the successor. So you have two separate companies doing their own thing with no ownership
So two
interest.
separate companies doing their own thing.
Which means the jurisdictional
The predecessor
contacts are
exists in
different.
some form, right? So they would have, the court would have jurisdiction over that predecessor. Am I correct?
Absolutely
I'm
would have
following this
jurisdiction
argument
over the
so far.
predecessor.
Okay. And then your position is, so then they should sue that predecessor? Am I
Absolutely.
Following you? Okay. The predecessor has entered this agreement where someone else holds the liability, so the predecessor would
Certainly
what,
could
bring them in
bring-
as a third party?
LCB could have brought, if they thought that SGBL was responsible for the tort,
Yes.
they certainly, well, they had every opportunity and would have brought SGBL in. And plaintiffs could have, at that time, brought them in also. The key thing here, though, is that New York law already has ample tools to handle these problematic situations.
Could
None of
there
which-
ever be personal jurisdiction in an instance where all of the assets and all of the liabilities are bought?
I think, again, if the analysis that the courts have used, and this is even in the North Carolina decision, is that when, and the patent decision out of the Fifth Circuit is when the entities are one and the same, they are. And a merged entity is essentially,
So one needs to disappear, so to speak?
one needs to disappear, or courts have also found where the predecessor actually has an ownership interest in the successor and is just merely abusing the corporate form or is trying to secret assets out of.
But there
out
is,
of-
is there not in the courts already an exception for fraud, which is closer to what the Chief Judge was asking your opponent about before?
Absolutely. The New York tools that already, the tools in New York that already exist are alter ego. If the two are one and the same, then the jurisdictional contacts are going to be the same. If there's fraud on the court
They fall short of alter ego, it's clearly done for some fraudulent purpose.
or a fraudulent purpose, that was actually
my
presented
point.
in the North
That was my
Carolina
point.
case.
So then you'd have the trial on the fraudulent purpose, and if you find the fraudulent purpose, if that's the finding of the court,
I would accept.
then you would say personal
Then
jurisdiction
I
is
think there would be
appropriate?
personal jurisdiction.
And
because,
what theoretically is the reason for that?
well, courts have always had an inherent power to exercise if a company or if a bad actor is trying to avoid jurisdiction. And at least this court's opinions have held that that's actually a fraud on New York. And therefore, that represents some personal activities under the long-arm statute that would allow you to reach a company in that situation. But none of the unfairness concerns are presented with an asset and liability purchaser. SGBL had no connection to any of the tax. There's no ownership interest. It's not a corporate reorganization of LCB.
Well, did they plead that? Did they plead it was fraudulent? That's another reason
They didn't
to
call-
exercise personal jurisdiction, putting aside the merits of the claim, not before.
Most of the arguments that we're hearing today and your questions are really not even presented by this case because the plaintiffs have never argued that the long-arm statute applied. They've never argued personal availment, that SGBL did anything. They haven't argued merger. They haven't
So
argued.
it sounds like under your recommended rule, they can, if the predecessor exists, they can sue the predecessor at the time they want to bring the lawsuit. They can sue the predecessor in New York because the predecessor, we
Or
would have
afterwards,
personal
yes.
jurisdiction over
Yeah,
them.
absolutely.
And/or sue the entity that assumed the liabilities, wherever they can
Wherever
get
they can be-
personal jurisdiction over them.
Wherever they can be
correct?
found. And the Simmons Court actually made that crystal clear. And this court has consistently found in Feathers and in a host of other cases that liability and jurisdiction are two different concepts. And the question
Can you
of
move to consolidate those cases once you do that?
you probably could. You could either bring them, you could sue the two entities together, you could bring it separately. But this court has consistently recognized that liability and jurisdiction are different, and you have to decide the jurisdictional question before you even think about the
Can
liability
we
question.
go back to the fairness question
Sure.
for a minute? So if I'm understanding the timing correct, and correct me if I have it wrong, So the attacks at issue were in 2006, and I believe there was a separate action, but based on some similar theories, filed against LCB in 2008, is that right?
That's right.
And then in 2011, the Treasury Department designated LCB a primary money laundering concern, and then this deal took place a couple months after that,
Yep.
right? And so I would expect that, especially as sophisticated a player as your client, would have considered those liabilities and priced them into the deal. So help me understand how the fairness concerns play out here.
Yeah, the plaintiff's argument has been that somehow that you can unmoor the liabilities and the jurisdiction, and that's not so. As we know, you can sue LCB and you can get that, the $600 million, which is far more than what they've, asked for here. And a company, the expectations of SGBL is not the same as the personal jurisdictional analysis that this court has to make under 301. It's not a foreseeability analysis. Purposeful availment and foreseeability are two different things, and even...
So that seems like it's an ex ante, ex post question, right? In other words, would it be the case that if we were to have a rule that applied prospectively so that anyone in the market that was going to look to do a purchase of all assets and liabilities would take that into account, it would be different? Is it a notice proposition or
Yeah,
something else?
It's a very difficult rule because it would represent really a sea change in asset and liability purchases and in jurisdictional law because...
Well, I'm not sure the court has pronounced on it yet, so
Yeah.
I don't know if it would
No,
represent a sea
yeah.
change. But
Plaintiff's theory, taken to its logical conclusion, means anytime there's liability of a company, there's personal jurisdiction.
Well, could you write into the agreement that the party does not waive any personal jurisdiction challenges it may have?
Yeah, I mean, the parties, the two contracting parties are free to come to any agreement that they have. We're here,
I'm saying if we agree with them, would it be possible for the parties to say, or the party to negotiate, I don't want to fall under that rule, I want to avoid that rule, and so I don't waive, right?
Yeah.
You'd make your decision if there was a lawsuit at the time, whether or not it's beneficial to your client, to nevertheless subject yourself to personal jurisdiction in New York, right?
Yeah, parties are free to contract and limit their liabilities and limit the assets, obviously. Here, we're here on a motion to dismiss, where plaintiff's allegations have to be taken as true, and they alleged that SGBL assumed all the liabilities and all the assets. And we don't have an opportunity to contest that at the motion to dismiss stage. So
But
that's
let me-
where we
if-
are
if-
now.
If I may, just to clarify your responses to Judge Halligan, if I'm understanding you correct, it may be a crude way of putting it, but it seems to me what you're saying is that when you negotiated the price, you negotiated, we may be liable for X, Y, and Z, and that'll be this amount, but you weren't negotiating, and wherever we've got to defend that liability, that'll always be New York, or that will include New York. You're saying that wasn't part of the
Yeah.
price point.
Yeah, that wasn't, it's not in the record of what
You're
the
focused on the
agreement
liability
says.
itself, not
Yeah.
the form.
Plaintiff's theory is purely that a liability equals jurisdiction, and as I said, our position...
No, I'm saying that in response to Judge Halligan, I think she was getting to this point, and as they argued in their brief, you're already factoring that into the price. And you're saying, no, that's not being factored into the price, if I'm understanding you.
I think that's right. I mean, I think this is, this is a corporate transaction. You can't affect the rights of a third party against you. You can react against, you can insure against, you
no,
can...
but you surely can negotiate with respect to the scope of liabilities that you're assuming, right?
Certainly. And that's why
So if you
LCB...
want to carve something out, you can certainly
You
do
can,
that.
absolutely. And if, again, if LCB thought SGBL was responsible for the liability, they certainly could have and would have brought them into the lawsuit. And I know you asked one question about the Southern District, and I see my time is up, if I may.
Please go ahead.
There was some monies that were held, frozen by the Justice Department involving the transaction, and SGBL came in and filed as an innocent owner in the asset to respond and make a claim in that asset forfeiture action. And in it, it expressly reserved all its rights to personal jurisdiction. It was not subjecting itself to jurisdiction in New York or otherwise. It was filing, as federal law allows you to do, a claim as an innocent owner. And what SGBL was saying is, in the process
Without
of the...
purposeful availment.
Excuse me?
Without purposeful availment of performance.
Certainly, and it certainly doesn't arise from the suit, which is really what you need in conjunction. The activity has to be suit-related for purposes of specific jurisdiction. So not only did they reserve the right, but it certainly had nothing to do with, the lawsuit that was filed almost 10 years later. So,
Thank you.
thank you very much.
So as your honors heard, defendant's view is that what makes sense of their theory that you would apply the long-arm statute essentially twice to predecessor and then to successor is that they're the exact same entity. The entity is only moved and it no longer exists here. That's not true for, first of all, for all the forms of successor jurisdiction in New York, as the Eastern District held, but relying on First Department cases, and this is in a successor jurisdiction case. This is Gould v. ILKB. To the extent the successor defendants argue successor liability pursuant to a de facto merger requires ILKB's dissolution, New York law holds otherwise. So it's already not the case in de facto merger. Now, in a de facto merger, where you have a sort of defunct shell left in the jurisdiction, which is what we have here precisely,
Well, 580 million being defunct, okay.
well, the question is whether there's the LCB would implead SGBL to protect its assets. LCB is rendered defunct such that all of its creditors now are coming for that $580 million, whether the claims are already brought, as in the plaintiff's original suit against LCB, or those claims are yet to be sued upon.
But when you say they're a shell, what exactly do you mean, given the amount of money? I'm
Well,
not following.
LCB has no assets. The money was, it has no money. It represented to the United States Supreme Court that it has
So
no money
where's
to
the
pay a judgment.
$500+ million?
Well, the United States seized.
Frozen?
No, I don't know where it is as the plaintiff, but it's LCB who has represented the Supreme Court that they have no money. I don't know where it went. Some the United States took due to their wrongdoing. Some may have gone to other creditors. I don't know. They're in liquidation in Lebanon, so I imagine it's gone to creditors in Lebanon. But they have no incentive, and I think this even goes to the Chief Judge's question about insurance. They have no incentive to implead SGBL because they have no money to get back. They have no assets which could be seized. They effectively don't exist except as a shell corporation. So
I'm not
unlike,
so sure about that. It depends on what the liabilities that were assumed by SGBL are, right? I mean, they may have already paid out claims that are really liabilities. I don't know that, what the terms of that are exactly, but there may be some money they can get back.
that LCB could get back from SGBL.
Yeah, if LCB paid out claims that were subject to the assumption of liability in the contract, I assume they'd be entitled to recoup those.
Oh, claim monies that they've already paid
Yeah,
after, well, they
yeah.
entered liquidation and then were purchased by SGBL. So perhaps other creditors could do some sort of clawback action in Lebanon, I don't know. But here in New York, they have no incentive to implead, unlike an insured party, SGBL, because they have literally nothing to lose to plaintiffs.
So I'm curious about one thing in your complaint that may not amount to anything, but your complaint is filed long after the transaction in question, and yet it alleges that up to the present time, LCB is engaged in the various terrorist activities that you're complaining about. It seems as if you assumed, even when you filed the complaint, that they were still an ongoing business.
I believe, I don't have the site in front of me, I believe the complaint says that LCB,
It says, including the period between 2004 and the present day, LCB carried out the Hezbollah wire transfers and provided Hezbollah with other banking services.
oh, that period ends in 2011, because once the United States designated LCB, it lost the capacity to bank through New York correspondent banks. So it's alleged in the complaint certainly that it ceased banking operations as of 2011. I see that's my time.
Did you have one more point you wanted to make? I interrupted you.
I did, no, thank you, Your Honor. Just about liability and jurisdiction not traveling with each other, just to make clear, of course, acquiring a liability in the sense that if you are in California and you're a non-New Yorker and you assault a New Yorker, you have liability to that New Yorker. But there's not jurisdiction over you in New York on those facts because all you have is liability. The issue here is the liabilities are liabilities that arose in New York under this court's 2012 Leachy decision. The liabilities are to claims in New York, including ones that existed already, brought, and ones that had already accrued. These liabilities accrued in 2006, but had yet to be brought. So to be clear, there's a difference between liability simpliciter and liabilities for claims that have a relationship to New York, in the sense that the jurisdiction already attaches there.
And then, I'm sorry, just to follow up, to be clear on the other point you're making with that. Therefore, when they negotiate this purchase, they understand that there are some liabilities, I don't know if they're all, but certainly the ones you're talking about, were incur in New York to the extent that the predecessor would have been subject to personal jurisdiction in New York. And so that's something that they understood at the time they entered their agreement. Is that in part what you're?
Sure. I mean, they already had, of course, the lawsuit that sort of precedes this one in New York, but knowing this full scope of Hezbollah's attacks on Americans, for example, and knowing that the Anti-Terrorism Act exists, then they would know not only about that suit, but any number of claims that would have accrued up until the purchase in 2011, as in there were injured in that time.
But then anticipate that the lawsuits would at least start in New York. Whether or not they can proceed in New York is another story, but that there would be people seeking to bring these claims in New York.
Right.
That's the link, okay.
Yes.
And to sort of take your last example and change it a little bit, a minor who is domiciled in California with the minor's parents comes to New York and injures a New York resident. Can the parents be sued in New York? They have legal liability for the minor.
Just working this out. So the minor has come to New York. They have legal liability for that minor.
And the parents have never set foot in New York.
Right. I don't know. It's a good question. I mean, if the reason why the plaintiff, those are all good questions, right? It's your job. But if the issue of the liability is because that the minor is judgment proof, for example, then yes, it may be appropriate in that circumstance where, there's nothing else to be done for the plaintiff except chase the parents around the world.
Or they're the guardian and they're responsible because they allow the child to come to New York and they're responsible for conduct that happens in New York that may be a tort.
Yeah, certainly. Another possibility.
There you go.
Take it. All right. Thank you very much, Your Honors.